Good afternoon, everybody, and welcome to the first technical session of today. My name is Justin Deal, and I'm Chief Technical Officer for the Insolvency Service, and I also head up the Chief Exec's technical team. Part of our role, as Mark Austin mentioned earlier this morning, is to work across government and the insolvency profession with regard to these kind of national interest, public interest potential insolvencies. And it's a very secretive world of project names and insider lists, and we don't get to speak about these very often until perhaps they do fall into compulsory liquidation. And much of the work that we do does go into that pre-planning stage, and most often there are solutions that do not involve compulsory liquidation. But as you will know, we have dealt with British Steel, Thomas Cook and Carillion over the last few years, and I now know far more about the steel industry, closing down a blast furnace and salamander taps, and I never thought I would need to know. If you're interested, they're fascinating, but go away and have a look. So today's session is a session that I'm really interested in, and it's presented by Inga West of Counsel for Ashurst. And should administration or compulsory liquidation be the process of choice for large strategic insolvencies? So as I mentioned, this is being presented by Inga. Inga is a specialist restructuring and insolvency lawyer, Chair of the Insolvency Lawyers Associate Technical Committee, a member of the Experts Group to the Insolvency Service, and a distinguished practitioner member of the Commercial Law Centre at the University of Oxford. There will be opportunity for questions at the end. If you're online, then please post your questions on Slido, and as I say, we'll pick those up at the end. So without further ado, over to Inga. Thank you.
Thank you very much, Justin, and to Laura, the moderator, and also, she's not in the room, but Laura Bardsley, for doing such an excellent job of organising us and making this event happen. It's a real delight to be here to present in person. So I'm also very grateful to you in the room. Good to see a few more than there were here at actually 12 o'clock, and also to those of you online. I'm very conscious that downstairs we've got a very eminent, one of the sort of UK's leading insolvency academics, talking on a really interesting subject. So I'm grateful that you've chosen to be here. Although, as I said to Pete earlier in the week, we're both members of the ILA Technical Committee, the Insolvency Lawyers Association Technical Committee. So I prefer to think of this as sort of an ILA monopoly rather than a competition. Although I'm not officially wearing my ILA hat today, if there's anybody listening in who's interested in joining, we're very much welcoming new members at the moment, so please do look us up. So with my Ashurst hat on, I want to discuss the question, should administration or compulsory liquidation be the process of choice for national interest insolvencies? And it's really good to consider this question. As Justin said, so much goes on in the background when you have a contingent case appearing. It's really good to consider this without the heat of an imminent filing, to think about this. And just in case you're worried, I am going to stick to publicly available information for this talk. I know there are a lot of sensitivities around it. So just to get us in the mood of the sort of industries and sectors we are talking about, there's a picture. I want you to cast your mind back to 2015. You mentioned British Steel and Carillion and Thomas Cook. You didn't mention, I'm going to get this right, Sahaviria Steel Industries, otherwise known as SSI. That goes back as far as 2015. But if that wasn't a large blip on your radar, think about what you were doing in January 2018 when Carillion collapsed. It was a bigger, more memorable case, I'm expecting. So among the shock and outrage of the Carillion shenanigans that had gone on and that hit a lot of the headlines, I think among the insolvency community, there was some surprise. You know, when the headline first hit, was it really a liquidation? Did the journalists get that right, or did they mean administration? I thought liquidation meant that employment contracts terminated automatically, right? And the company also has to cease trading. How does a trading liquidation work? And why didn't it go into administration? I mean, after all, isn't administration our process of choice for trading insolvencies? And these are all, of course, very valid questions. And we know, of course, that you can trade a liquidation and the employment contracts don't necessarily terminate. But we didn't necessarily know that at the time. 2015, I think, was the first of these sorts of cases. So in terms of methodology, this is a qualitative paper, it's not a technical legal research paper. We went out into the market and we spoke to some of the leading insolvency practitioners who'd taken appointments as special managers on these cases, and a leading QC and a leading solicitor as well. I'm not going to divulge their views because we keep it confidential, but their views were aligned, strikingly so. There was a consensus of opinion about some of these issues in the market, which is useful. And then, as a small spoiler alert, before I move on, I'm going to say that I don't actually answer the question because we didn't get an answer. You know, it's going to be a classic, it depends. But there are lots of very interesting points to talk about as we go through. So, this is our agenda for the next 20 minutes or so. First of all, we're going to speak about, I'm going to go through some of the national interest cases just to remind ourselves a little bit about what they're about and why they were national interest cases. I'm going to look about using the research that we did, the factors influencing the choice of administration or compulsory liquidation. We're going to consider some pros and cons of compulsory liquidation for national interest cases. And also, this is a policy conference, so I'm going to give you some reforms to consider, or some potential for reforms to consider. And then towards the end, we'll just weigh up the factors. So, these are the national interest cases. Oops. So starting then with SSI, you'll notice I didn't try and say the name again. SSI owned the Redcar Steelworks on Teesside. It went into liquidation in October 2015 following a global collapse in the price of steel. And PwC were appointed as special managers. The buyer could be found and the steel were announced they were going to close after about 10 days, affecting about 2,200 jobs. And after the closure, long closure, I think the site was transferred for redevelopment and regeneration. So that was SSI. It's not such a well-known case. Carillion, much more well-known, January 2018, second largest UK construction company, and it was listed on the London Stock Exchange, and it employed about 43,000 people globally. About half of those were in the UK. But the real national interest factor for Carillion was that it supplied many essential public services to HM government, including things like cleaning, school meals, hospital maintenance and defence accommodation. And it also had a range of public and private construction projects, including hospitals and transport. So it was really sort of key into our national infrastructure. And famously, at the start of the liquidation in January 2018, it had just 29 million in cash at the bank against group debts of something in the region of, I think, ultimately it was understood to be about 6.9 billion. So there was insufficient to fund the administration. And I think that's what drove the national interest in that case. It was another PwC case. PwC were partners, were appointed as special managers. And the official receiver and the special managers traded the business pending transfer of many of its contracts, sort of to keeping those government services going. Next up, British Steel. It was May 2019. This British Steel was the second largest steel producer, and it operated steelmaking and processing facilities in Scunthorpe on Teesside. I think what spelt the death knell for British Steel was a fall in the price of steel, declining demand due to Brexit uncertainties, and competition from alternative suppliers. And it's interesting that you don't always get a winding up judgment with these cases, but we did in this case. And the judge actually cited significant environmental and health and safety concerns as factors he took into account. Justin knows an awful lot more about blast furnaces. Well, you can't just turn a blast furnace off. It will a huge risk of explosion if you do. So you can't just walk away from a steelworks. It needs managing very carefully. And the judge was very alive to that. He said it was essential that skilled supervision continue in a controlled manner within a formal insolvency process, and that was the basis on which he was happy to make the winding up order. Special managers from EY were appointed. The collapse put about 5,000 jobs at the plants in Scunthorpe, Teesside and Skinning Grove at risk, and jeopardised a further 20,000 in the supply chain. So as well as being sort of systemically a systemic threat to the steel industry in the UK, or what was left of it. It was also of socio-economic impact to the northeast. Good news that British Steel was, as well known, was eventually, or its plants were eventually sold to a Chinese buyer in March 2020. So, a little under a year, and that was when it completed, little under a year after it had gone into liquidation. Huge cost to the taxpayer, though. I think publicly a sum of 500 million has been touted as being a sort of taxpayer sum. So, it's some big decisions, policy decisions for government on which I am not going to touch. Thomas Cook was the next one dear to my heart because Ashurst acted. So Thomas Cook was one of the nation's largest holiday companies, a tour operator and an airline. And after 178 years in business, it toppled into liquidation due to over-levered acquisitions back in 2011 and the internet revolution of holiday booking online. Partners from Alex Partners and KPMG, which became Interpath, were appointed as special managers over different parts of the group, and we acted for both sets of special managers and the official receiver. Little known interesting fact about Thomas Cook, for those of you who've been very involved in it, this is not the first time that Thomas Cook faced insolvency. It also did so in 1948, after the Second World War. And did you know it was actually nationalised in 1948 until 1972? It was part of British Railways. So there you go, pub quiz trivia. But clearly didn't have quite the same place in the national heart in 2019, and it was not nationalised then. So what was national interest about Thomas Cook? Well, of course, it was the 150,000 holiday makers stranded abroad that needed to be repatriated, I think was probably the driving force about Thomas Cook. Took nearly 800 flights to do that. And total cost, I think, of the repatriation was somewhere in the region of 481 million. Most of that was absorbed by the Civil Aviation Authority as part of their scheme. Probably quite depleted now. Let's hope another airline doesn't go bust too soon. And there was a top-up from government. And Thomas Cook's businesses were kept going. It didn't trade in the sense of like continuing to run holidays, but it traded to enable an orderly wind down. It sold several of its businesses, including its 550-odd travel shops to Hayes Travel, its Nordic Airline and its Spanish hotels business, amongst others. So those were the official receiver national interest cases to date. So we then move on to, well, so when is an insolvency a national interest insolvency? Well, the main point of this slide is actually the headings of the columns along the top. And unless you think I've made these up, I haven't. These are actually government's own criteria in the recent panel pitch that they put out. So the criteria, some or all, or a national interest case may have some or all of the following characteristics. So you've got a large, complex infrastructure, think like British Steel or Carillion maybe. So market-specific sector or socio-economic impact. So again, British Steel impact on the northeast because so many jobs at stake. Significant financial and reputational risk, probably something like Thomas Cook and your repatriation would be an ideal example. And significant environmental or health and safety risks, and I'm going to have to say here, it's the steelworks. It's the risk of that blast furnace explosion or the horrible polluted site that British Steel maintained. So, next up, official receiver cases started. Official receivers cases started in 2015. What did we do before then? Well, there cannot have been the first national interest case ever occurring in 2015. There must have been others. So here are some others to think about by way of comparison. And actually, probably, if I was doing this again, I would put Metronet on here as well. So let's take Railtrack as our first example. Oh, sorry. Thank you very much, yes. I'm going to pick Railtrack first because I think this is probably one of the sort of biggest national interest cases which didn't run as an official receiver case. I haven't asked the question, and perhaps somebody in the room could tell us whether they wish it had, but nevertheless, anyway. It was definitely a national interest case. Railtrack operated the principal national railway networks responsible for the provision, maintenance and management of the railway infrastructure. Part of its role was to manage timetabling, train planning and signalling. Then the company's parent was listed on the London Stock Exchange. I mean, quite simply, without Railtrack, you don't have a railway in the UK. So it was strategically important. And when it failed, I think government needed a bridge while it set up its successor, which is Network Rail. Interesting point, Network Rail is about to be replaced. But anyway, that was it. They took it sort of back into public ownership in Network Rail. Railtrack was the first use of the specifically designed Railways Special Administration process. I think it's significant that it was a special administration. We'll come back to that. And there was an indemnity, it's public record that there was a government indemnity for the special administrators. Another interesting fact about Railtrack was how the special administrators got comfortable with the potential office holder liability, because office holder liability was one of the really big issues that came out of all of our interviews. It was a really big consideration in Railtrack. And there was indeed a fatal rail accident that happened during the duration of Railtrack at Potter's Bar. And I just want to, because I think when we think about office holder liability, I think we need to put this into context. I mean, this is seriously big potential liability we're talking about. I'm going to read you out a very short paragraph from the report of the Potter's Bar accident, where it says that at 12:55, travelling at 97 miles per hour, the 4-coach train passed over a set of points just south of Potter's Bar railway station. The points moved under the train, causing their rear bogie on the 3rd coach and the entire 4th carriage to derail. This caused the 4th coach to become detached and cross onto the adjacent line, where it flipped into the air. The momentum threw the carriage into the station, where one end of the carriage struck Darks Lane Bridge parapet, destroying the masonry and sending debris onto the road below. It then mounted the platform and slid along before coming to rest under the platform canopy at 45 degrees. The front 3 coaches carried on and came to a stop approximately 400 metres north of the station. There were 7 fatalities in that crash. 6 of the victims were travelling in the train and a 7th was a pedestrian killed by falling masonry debris. In the aftermath, a long time afterwards, both Network Rail, presumably as Railtrack's successor, and Jarvis Rail, who was the subcontractor responsible for maintenance of the points, were charged under the health and safety legislation. Jarvis ultimately took responsibility for the crash and compensating victims, and Network Rail was fined £3 million for safety failings. But the special administrators were not liable. Interestingly, at the outset of the Railtrack order, there was a handwritten change to the winding up order, which directed the administrators to consent to the directors' continuing responsibility for all safety and operational matters. It's really interesting, this, because this is actually, it's not something made up by the courts. That actually exists within the administration regime, the ordinary administration regime as well, Para 64 of Schedule B1. It's not often used or liked. In fact, we tried to push it when we were pushing the light touch administration last year, and IPs really pushed back. But the power exists in the administration regime for office holders to properly and appropriately consent to management to continuing their management functions. And Railtrack was a prime example where they had to do this, because the office holders are not the right people to manage the safety of the railway networks. They don't know how, it's not their specialism. You need to appoint the appropriate person responsible to do that. And it was a mechanism that worked in this case. So, very big liabilities we're talking about here, which is why they are such a concern. Even if they're low risk, they're so huge, you can't ignore them. Metronet was another example. It's not on the slide, but that was the infrastructure for the London Underground. And the point to note, and that was in 2007, and the point to note about Metronet is that it went into an ordinary administration. Again, it was government funded, but it went into an ordinary administration. Petroplus, another one. So that's Europe's largest independent oil refinery, 2012. It owned Corriton Refinery in Essex, and it was a key supplier of fuel to the southeast. When news of its pending insolvency struck, there were fears of a fuel shortage just ahead of the London 2012 Olympics. and it's another sort of heavy industry, large piece of infrastructure. Petroplus went into an ordinary administration, and it was dealt with by the private sector. And Paramount Airways is on there. It's not really a national interest case. It probably wasn't big enough, but I put it on there because it's the last example I could find of a flying administration. At the moment, the UK is a no-fly zone for insolvent airlines. We don't fly them. We just ground them. We're not. Other countries do it differently, but we just ground them. Back in 1989, you apparently could fly an airline when it was in administration. It was a charter airline operating out of Bristol, short-haul flights to the Mediterranean destinations. And it went into administration in August, and it traded for the rest of the holiday season, eventually stopping at the end of November when they couldn't find a buyer, but it flew. Recently, we've had Monarch in administration, and we've had Thomas Cook in liquidation, neither of which flew once the insolvency curtain had fallen. That's possibly due to changes to do with the Civil Aviation Authority and how they revoke their air operating licenses. Also relevant is the insurance position. I don't know what changed between 1989 and now, but something fairly big. There has, of course, been the Airline Insolvency Review, which issued its final report in 2019 about how to get insolvent airlines to use their own fleet to deal with the repatriation, so to lessen and use private sector funding rather than public sector funding, as we had to do on Thomas Cook. I think it was probably a Brexit casualty in terms of parliamentary time, because I don't think there was any other reason why it wasn't sort of examined and pushed forward. Then it was first Brexit, then the pandemic. Perhaps it's something that ought to be sort of brought out of the drawer and had a look at again, because I think possibly airlines could be a sector that could be taken out of the national interest bucket, possibly don't really need to be there. So, factors influencing the choice of procedure. There are lots of factors, but they primarily fall into two different buckets. The risk of liability, and I'm talking about office holder personal liability and unfunded administration expenses in the same bracket here. And that's on the one side. On the other side, we've got funding for those issues, so cash flow, insurance, or some indemnity coverage to cover those issues. I will also consider special administration, because I think that it's sort of falls as a sort of subcategory of the indemnity point. But let's have a look at the office holder personal liability and a sort of administration expense position. So the IP's approach, when we spoke to them, their approach to potential liability as administrators, they all raised it as one of their first considerations when you're considering, will I take the appointment? And that's the case notwithstanding. I think the risk of personal liability is really low, but nevertheless, it's almost a zero tolerance approach. There are some cases where they can get comfortable on due diligence on the state of the assets and that sort of thing. I mean, there have been fairly recent examples of power stations going to administration, and airlines, etc. So it's not that there is no industry which is entirely off limits, but if there's something like British Steel, where you've got a legacy of 100 years of pollution, really rotten site, you've got blast furnace explosion risk, you've got a slag heap that might collapse, these types of things, I don't think you're going to find an insolvency practitioner that's willing to take that on the chin. If there's any risk, even if it's small, it's going to be a zero tolerance approach if you can't cover that risk. So the type of the risk that we're talking about largely falls under the environmental regime and the health and safety regime. And there's a real tension with the insolvency the insolvency regime between those two things. And there's also some potential tortious liability, but let's stick for the most part with environmental and health and safety. And in addition to potential liability, there's also a PR issue, because even if you can get comfortable with, like for example, if rail track happened today, can you imagine the unkind headlines around fatalities when EY is in charge, sort of type of headlines. And I think that the attitude towards PR has sort of become more cautious over the years, and perhaps as the media have become more aggressive. So one of the questions that often IPs considering a role will ask, and they take legal advice, is, what's my risk? Can you rule it out? And the problem is that you can't. The environmental and the health and safety regimes prescribe who should be liable. Liability can be both civil and criminal. And they're not drafted with insolvency in mind. Parliament just simply didn't have it in mind to sort of stipulate whether an insolvency office holder in office is going to be liable or not. So whereas you can usually get to the point where you think, well, it's quite a low risk that you'll be personally liable, possibly slightly higher risk that there might be an administration expense. But we all know the Nortel guidance. You have to try and divine what Parliament intended, and when Parliament doesn't tell you, that's quite hard sometimes. So if you're looking for a zero tolerance approach, you're not going to get it from a legal opinion, unfortunately. The last point on this slide is that I think there's been a reduced, and our interviews bore this out, that there is also possibly a reduced risk tolerance in recent decades. Why might this be? We speculate. Firstly, well, we're living in a more litigious culture. That's for sure. People will sue more often than they used to. I think there are increased PR concerns, as I just mentioned. I think that the environmental and health and safety regimes have increased their penalties and the criminal nature of their liability. I mean, for example, the last blast furnace explosion that happened in Scunthorpe was in 1974. There were 11 deaths, and the company was fined, wait for it, a whopping £500 after admitting failure to ensure the safety of 2 employees and a further £200 for failing to supply 3 workers with protective clothing. I think that amount is about 5,500 now. Today's prices add several noughts, or 6 or so noughts probably. And I think the final point is that we've had a shift away from trading insolvencies towards pre-pack administrations over the last couple of decades. So our army of insolvency practitioners, gallant though they are, have not grown up doing trading administrations, and they're not used to sort of used to sort of taking the risks that trading insolvencies normally take. It's just not in their DNA, perhaps. That was one person's view. So, other side of the coin, we talked about liabilities, just talking about funding. I think we distinguish between cases where there's a funding need because there's not enough cash in the pot, like Carillion, or cases where there's a funding need to cover some unquantifiable, unfunded administration expense or personal liability risk, like a blast furnace explosion. I keep coming back to that, but that is the sort of epitome of the example. If you can get insurance, well, that might be a way of covering it, but it's going to be tough and it's probably going to be very expensive. I think the availability or unavailability of insurance is one of the big reasons why airlines, we're a no-fly zone and airlines don't fly. And then that sort of brings us to sort of the government indemnity or funding. And this is all very sensitive, except where it's a matter of public record. So I'm going to stick to the public record so I don't get onto sticky ground. So we've had cases where the government indemnity or funding has been available, both in official receiver cases and non-official receiver cases. I mentioned some of them along the way. And then, of course, we have the special administration regime, if I can mention that here, because the special administration regimes are set up with a public interest objective, as you know. And also, nearly all of them, well, I checked the water, the railways, the air traffic control and the protected energy companies, and they all expressly provide for the government or the Secretary of State to be able to give an indemnity to cover the losses suffered by the office holder in performing his or her functions. Sometimes it's with the consent of Treasury, but nevertheless that exists. But I think we've seen the shift towards official receiver cases. I don't know whether that is, I speculate, is there been a change in appetite at government level, because they were prepared to give indemnities, Railtrack and sort of Metronet, those types of times, but not recently. I think it's true to say that where you have an official receiver case, although they don't have actual legal control or influence, but they certainly, I think that's possibly more of a comfort factor around the fact that you've appointed a civil servant to be responsible for the, sitting at the top and holding the pen on the checkbook. So that, I think, is sort of a flavour of the funding issues. Pros and cons of compulsory liquidation. I'll notice the time. So on this one, pros and cons of using a compulsory liquidation for a trading insolvency. So on the left-hand side, you've got the pros, and towards the right, you've got more of the cons. So I put there, I mean, I started off approaching it thinking, well, we should be able to find a way to make all of these administrations, because I grew up thinking administrations were what you use for a trading insolvency. I've sort of, having done this, I've sort of, I'm coming out somewhere in the middle, and actually I think the fact that we have the option of an official receiver process is of real benefit. They don't have it in Scotland. So what do you do when you have a case that the private sector won't take? And you don't have an official receiver option? I think it's a real benefit, and I don't think we should shy away from that. I think there is a purist argument that says, if you're, liquidation shouldn't be used for trading or business sales, etc., or not trading towards a business sale. But do you know what? I think that's too purist. I think we should be pragmatic about this. If you need an official receiver case, let's use one. We've got it, right? Big advantage of liquidation was mentioned in one of the earlier sessions: power to disclaim. Probably leave it at that, especially when you've got polluted land, for example. Big help. Limited power to trade. So we're in the middle now, it's neutral. I mean, the power to trade in liquidation is insofar as is necessary for the beneficial winding up of the company. It's a bit less than administration, but gets you there. It does the job, I think. I mean, there are some restrictions around it, but you can find your way around most of the time. And then towards the right-hand side, you get to the point about not designed for trading. I'm going to pick up the bullet points under that on the next slide. It's not perceived as a business rescue. Well, of course, liquidation isn't business rescue, but in fact, if you manage to sell it, you have kind of, preserved the business. Do we really mind about that? I think everybody now knows that it can be used for that purpose. Taxpayer exposure, and I've got that on the right-hand side, but actually, I mean, I don't know if anybody would ever be able to do an analysis of whether it would have cost more in an official receiver case compared to an administration case. I think you're never going to have the control. I don't know what the answer is. Most of these involve huge amounts of taxpayer money, but probably would anyway, whichever process you went through. So actually, even Stevens on that one, possibly. And then nearly there. On this one, so this is pros and cons. Sorry, no, it's not. It's reforms. Oops, where am I gone? Right, so reforms. So these are suggestions, merely suggestions, and they are designed to be not for the entire administration regime or for the entire liquidation regime. So I think these are suggestions for how you might make administration a little bit easier to do a national interest case, assuming that it's more of a quasi-liquidation administration, or at least it's an objective paragraph 3.2, sort of B and C, and not 3.1a. So we're not in rescue territory. And then compulsory liquidations, I think it's really important to note that I'm not suggesting that we do this for all liquidations. I'm suggesting that these could be, for example, a day one order ability. Give the power court to do that, or perhaps apply them to all trading liquidations, of which apart from official receiver cases, there's almost none. Although perhaps you never know, there might be a trend. Just taking I haven't got much time, so I'm going to go through the liquidation ones. I'll leave you to think about the administration ones. So think about introducing an administration style moratorium, because if you're trying to trade it, that can be a help. I mean, on Thomas Cook we didn't have secure creditors, but if you've got secure creditors and they're not playing ball, it's going to be really tough to do a liquidation. Employment contracts. Yeah, that issue. Do they terminate automatically? Do they not? Well, of course, I think we're getting reasonably comfortable that they don't, but that rests on some really ancient authority, and it would be good to straighten that out, I think. Power to deal and dispose, or express power to deal and dispose of floating charge assets. This is another little wrinkle, that the power that exists expressly in the administration regime to deal with floating charge assets, and then the power to apply to court for consent to dispose of fixed charge assets doesn't exist in the liquidation regime. That, again, if you've got hostile or opposing secure creditors, that power would be really useful. I think there's an opinion, a QC opinion out there that you can imply it, and maybe that's good. But again, another one that would be good to clarify. Section 233A, I think I'm short on time, but that one doesn't apply to liquidations. I think if you're trading the liquidation, it should. That's all to do with the protection of essential supplies and whether they can terminate their contract. And by the way, ipso facto doesn't help because it's carved out because it's all part of the Section 233 carve out. Set off, and that was one mentioned by some of our interviewees, saying that when you go into liquidation, you've got immediate set off, and when you're trying to trade a business like British Steel, for example, it might be easier to do that without set off kicking in until a bit later, like it does in administration. So that's those, and then we get to the final slide. So this is where we end up. This is my it depends slide. Compulsory liquidation administration. So I think if you've got a large unfunded and quantifiable environmental, health and safety, personal liability or administration expense, that's going to tip the scales down towards compulsory liquidation because you're going to really struggle to get an IP to take that appointment. Industrial sector, if it's really dirty and heavy, again, tips you towards compulsory liquidation. I think it's the flip side of the same point, really, because that's where you're likely to have larger liabilities that are difficult to pin down. The next one, whether there are assets available for expenses and funding. So this is your Carillion problem, well, one of your Carillion problems. If there aren't enough and it's a case that you can't just let go, like Carillion, then you're going to be in compulsory liquidation territory. And then on the other side of the scales, you've got, if there's an indemnity available, well, we've seen administrations work in dirty industry cases where there's an indemnity available. If there's a possibility of a full business pre-pack, that gets over some of the liability issues. That would tip it to administration. And finally, if there's a special administration, now I know there's a whole debate going on around the proliferation of special administration regimes. Let's not time to go there today. But they are designed, I suppose, to address a particular public interest problem. And if you've got one, then I guess you'd use that over compulsory liquidation. That concludes what I've got to say.
Sorry. Thank you, Inga. That was fascinating. Obviously, an area that my team work a lot on, and we hear those arguments quite a lot across government. And it's interesting that you've come to the same conclusion that we have. Really, there's a role for both those to play in these cases. Compulsory liquidation doesn't always work for some of these national interest, wider government policy objectives, and it's quite a challenge sometimes to align those. So it was really, really interesting talk this afternoon. Thank you. All right, so some questions. Okay, I'll open it up to the room. So if you could introduce yourself first and briefly what your role is, and then the question would be great.
So hi, thank you, Inga, for your presentation. It was quite interesting and really well made. My name's Asad. I'm Dr. Arid's PhD student. And I want to link your presentation to what we heard earlier by Sue Morgan regarding CVAs. Based on the question, I'm guessing it was Dr. Mokal who pointed out that a regime which you choose essentially depends on a range of factors. And Sue Morgan's research tends to suggest that CVAs are the best solution going forward. And I wanted to ask your opinion. What do you feel her research suggests in terms of large insolvencies, and whether or not you feel her research and findings are relevant to your paper?
Thank you, and it's a good question. I think I would fall back on her reference to the Cork report, and another sort of tome dear to all our hearts, in which the Cork committee promoted and designed, with the architects of the voluntary arrangement, and it was designed to be a small company piece. Now it is used now by, notably by tenants in retail businesses, large ones. I don't think, I feel it was very appropriate for these types of cases. For a start, in a CVA, you can't deal with secure creditors. And 3 out of 4 official receiver national interest cases had secure creditors. And also in a CVA, the debtor is in possession. Whereas I think, in all of these cases, there's been a need to appoint an office holder to take control and assure, various safety procedures and things are in place. So, yeah, I think I would say probably not in this in this space.
Any more questions?
Irit Mevarak, University of Nottingham. Thank you very much, Inga. I thought this was really interesting, excellent presentation. Quick 2 questions on the previous slide on the reform suggestions. So first, are you suggesting these fixes to administration and to trading compulsory liquidations only for these nationally important companies, or generally do you think that we need those fixes? And then do you think that that will result in equalizing administration and liquidations with regard to trading insolvencies? And if we are making them quite similar, are we then confusing ourselves again with too many tools? And what is the difference between these tools, and which one do we need to use in various cases? Thanks.
An interesting point, and thank you very much, Ira. I think I would say, in relation to the compulsory liquidation suggestions, maximum trading compulsory liquidations only, but at the moment I would say, I mean, I don't know if there's any data on it. Have there been any other than the official receiver cases? Possibly not. But I suppose, you know, when you make a change, it does drive behaviour. So that might drive behaviour towards trading liquidations, and that might be something as a policy that you don't want to recommend. So you could just restrict it. I think that the suggestion was driven from the point of view that there are some cases for which you need the official receiver option. And if you're forced into that route, you need a process that's going to work as well as it does. And in those cases, I think these suggestions would help. I think that's where I was coming from. But sort of beyond that, I mean, am I saying that, you know, you should change all liquidations to make it like administration? Well, no. But I also personally hold the view about administration that we're not using it nearly as well as we should be anyway, because it's supposed to be at the rescue end of the scale, and it's almost, you know, almost without exception being at the quasi-liquidation end of the scale. So, you know, there's probably debate for an entirely other day. But no, I think these suggestions are around cases which have to be going into an official receiver case.
I think, sorry, just following me on, I think I'd also like to add that the power to deal with fixed charge assets in a trading compulsory liquidation may be controversial, but be enormously helpful in some scenarios. I mean, it's a major stumbling block in a lot of work that goes on, and trying to find a solution to that is almost impossible, certainly in the short term, as there are long-term solutions, but not short-term solutions.
And it's quite a surprising one as well. I think, you know, it's not, everybody just assumes that it sits there in liquidation, but it falls out of the Leyland Duff case, in case you want to look it up.
Riz Mokel, South Square. Excellent, very interesting, Inga, thank you. I smile when you talk about whether it's been possible for there to be trading liquidations. Back when I was collecting data for my PhD in the late 90s, early 2000s, our 3 figures showed that around 10% of liquidations were trading liquidations resulting in going concern sales of the business in whole or part. I'm not sure whether the figures have changed since then. It's possible, given some of the trends that you're mentioning, that they may have changed and the number of, the proportion of trading liquidations has decreased, but that would be a regressive move, losing capacity to do something within liquidation which we used to be able to do when circumstances called for it. And of course, as you point out, it's nonsensical to think about administration as something which is hermetically sealed off from liquidation. Our research shows, for example, that something like 1% of administrations end up rescuing companies as a going concern with a trading business. Most of the administrations are what we would call liquidations, where the business is sold off in whole or part as a going concern, or perhaps even liquidated properly, so-called. So I think it's very misleading to take the textbook treatment of liquidations as liquidating and administrations as preserving businesses. Take that as face value when you have even the most basic familiarity with the empirical facts about how these procedures operate. That hermetic sealing just doesn't exist. I do want to go back to Irit's point, which is that I think that most of these changes that you are recommending in relation to administration on the one hand and compulsory liquidations on the other, they are sensible, they have a lot to be said for them. There is very little to be said for restricting them to large cases. There's everything to be said for not creating hermetically sealed, supposedly silos of procedures, and you have to decide ex ante whether it's going to be one outcome or another. For one thing, those predictions may not work out. You may not have sufficient information ex ante to decide whether this should be the sort of case which ends up in a rescue of the business or a sale of a going concern or a liquidating sale. So why not leave that possibility open for a later stage in the process? One final point on the use of fixed charge assets and indeed assets subject to a mortgage. This is not a Leyland-Daff problem, and I've written about Leyland-Daff. I have some familiarity with that. This is a David Lloyd problem going back to the 1870s. And it's this very, very badly misunderstood Court of Appeal judgment where the liquidator was challenging the security pursuant to which the secured creditor had appointed a receiver. And the Court of Appeal decided that in those circumstances where the secured creditor could not get the treatment that they would get by virtue of their security, because there was this conflict that the liquidator on behalf of the unsecured estate was challenging the validity of the security. In those circumstances, it was appropriate to permit the receiver appointed by the secured creditor to seize assets out of the hands of the trading estate, the liquidator, out of the liquidator's hands. And that then subsequently got generalized to think that this was a matter as of right of the secured creditor, even in those circumstances where there would be no conflict between the liquidator and the interests of the secured creditor. So a purist, a doctrinal purist, going back to David Lloyd and actually reading the judgments, would see that in principle there is no bar to a liquidator being able to trade with secured credit, with the asset subject to a security, including a mortgage. That was a mortgage case, not just a fixed charge case, meaning that the title has been transferred by way of security to the creditor. So there is no principled doctrinal bar on this being used. It's just that this misunderstanding, in my view, has accrued around the use of security and the way in which they can or cannot be used, those charged assets in liquidation.
I think we're probably running a little bit over. So
saved by the bell.
Yeah, unfortunately, that's probably all we've got time for today. So thank you, Inga. That was absolutely fascinating.
Thank you.